Hello and welcome to this special programme by Reform UK into the Child Maintenance Service and its particular impact on the armed forces. We've got an amazing programme with 6 interviews from people in the armed forces, their experiences and the issues and the problems with the Child Maintenance Service. I'm delighted to be joined in the studio also by my special guests, Anne Widdicombe and Noel Willcox. Welcome to both of you. This is such an important topic that most people almost have no understanding of, and yet actually it's affecting so many people's lives so significantly, wrong amounts being charged, and the impact of that, the tension, the stress, the anxiety, leading to harm, and tragically, as I've discussed before on TV, even suicides. And how long have you been involved, been listening to and experiencing these challenges? What was the Child Support Agency and now the Child Maintenance Service?
Well, effectively, since the early 1990s, when what was then the Child Support Agency was first brought in. I was actually in what was in those days called the Department of Social Security at the time. And although I wasn't the minister handling it, I therefore had a very, very close connection to it. And the original aim was fine. It was that, there are too many people fathering children, leaving it all to the state and disappearing and never being seen again. And so the idea was that you had an agency which would pursue those fathers to make sure that children were being maintained and that it wasn't the responsibility of the state. That was the theory. The theory was a good one.
And the theory is a very good one. It's quite right that parents should pay for their responsibilities.
Yes, the theory was absolutely fine. It began to go wrong at a very early stage. We had suicides in the first few months of this act, of it becoming an act. First of all, of course, there are the calculations and the ability to challenge them. And that has gone steadily more and more wrong over the years, despite several reorganisations, and the CSA is now the CMS, but it's only changed in name. In practice, what happens is, largely men, but sometimes women, the absent parent is pursued for a sum of money which the Child Maintenance Service has calculated, which it doesn't have to justify, and which in reality, although in theory it can be, in reality it can't be challenged. And if a citizen wants to go to court and challenge an order, that citizen cannot do so once the CMS has issued the order.
And so let's just pick up on that, because actually from 2011, in a Work and Pensions Select Committee, there was a discussion between Stephen Timms and, Noel Shanahan on this particular point. Let's just take a look at this clip.
I think there's some severe question marks over the figure of 3.8. I think that the work that the department has done, the CMS has done, identifies that going back many years, we used to create something called an interim maintenance arrangement. Essentially, it was a number that was brought up to say to the non-resident parent, this is how much you'll have to pay. Actually used as a bit of a lever when they wouldn't give us their pay and information, which we have to ask for. So actually, it was inflated. It seems to be inflated by about 300%. So when they didn't pay, all those numbers have gone into the arrears. So the truth is actually those arrears are somewhat inflated because of the tools that were used up to 18 years ago.
Unbelievable. So they were deliberately inflating the numbers to use it as a sort of negotiating lever. I mean, Noel, you again, how long have you been involved with this? And what's your own experience?
Well, Richard, I've been involved with this now for about 5 years, conducted extensive research into the Child Maintenance Service because I have been significantly affected myself by these calculations. And as you said, rightfully so, every single parent out there is trying to, it has a financial responsibility, of course. However, what I'm seeing is that all of these parents, they're trying to pay the correct amount of money.
Exactly.
Yes. And that's been this ongoing battle that we've been seeing for a very, very long time, is that parents are doing everything they can to pay, but the state is inflating these incomes.
What I don't understand is why it's so difficult. I mean, it's quite right. You want to pay the appropriate amount of money. Sometimes people make mistakes, get things wrong. It should be relatively straightforward to say, okay, we've messed up there, we'll sort it out. And I'm guessing the vast majority are sorted out quite straightforwardly. But it does seem they actually pursue people without any evidence. We've got another clip here with Stephen Timms, the MP, and Joshua Redaway. Let's just take a look at this.
I've received, as I suspect a number of us have, quite a few sort of angry emails. I'm forwarding you case details. The Child Maintenance Service has been awarded a liability order for a fictitious debt. There are many thousands of cases like this one. In your report, I noticed you put a figure of 99.35% on the accuracy of the child maintenance calculations. Are you satisfied that the large number of people saying that there is a fictitious debt are mistaken?
No, we're not satisfied with that. We wouldn't necessarily use the word fictitious. However, it does mean that people are being pursued for debts that there is not the evidence to substantiate that they owe.
I mean, that is absolutely damning. Let's be under no illusion about that. Yes, there's obviously the vast majority, as Stephen Timms says, the evidence are correct. But the idea that the state would pursue people for sums that are clearly fictitious by their own admission is unbelievable.
I mean, the astonishing thing there, Richard, what I've kind of picked up on is just the lack of response from everybody. This is the thing that I'm bamboozled by, really, is the fact that there's an admission of inflation here, and nobody has said, sorry, can I just understand, that you've been inflating incomes? That's an admission.
I mean, I hate to say it, but this has got all the rings of another scandal that we've heard about with great tragedy recently, the post office scandal, when again, actually, over many, many years, it was known there was a massive problem and some things were covered up, sort of buried below the surface, stuck in the bottom drawer, and this has got that same sort of sense about it. And the examples we're going to hear with our special guests sort of indicate that, and the time it takes to sort this out. And obviously, this is going on in the civilian world, but why is it so particularly harmful and damaging to people in the armed forces now?
Well, because it compromises national security, really, Richard. That's what it is. If we're relying on our men and women of the armed forces to go out there and do a job, and the state is coming after them behind the scenes, then that's a very, very serious problem.
Absolutely. And the tension and the stress. I mean, it's hard enough keeping a family together when you're in the armed forces. As you say, when you're serving your country, when you might be overseas on operations for some period of time. But to have this sort of overload, this burden and the errors, I can imagine the tension, the stress must be horrendous, actually.
Well, as you've just said, I mean, marriage, it's well known that the military has quite a high divorce rate, separation rate. And when we are sending our men and women overseas, to protect our values here, we expect them to be looked after.
Absolutely right, we really do. Well, thank you two. Coming up, my friends, Anne is going to be talking to Lee and Craig about some of their experiences, that stress, that tension. Stand by.
Behind every case that comes to the CMS is an individual story. Now, of course, it could be a story of somebody trying to dodge their responsibilities. But all too often, it's a story of wrong calculations and then no clear avenue for appeal. And we'll see that even the courts themselves are prevented from examining individual liability orders. But are they all done individually? Let's listen to what Arlene Sugden had to say.
Are you ironing out with systemic delays? The liability order that I talked about earlier, which is the legal recognition of a debt, is legislative for us. And that requires you to take that to court. HMCTS have been fantastic in working with us, and I think the report reflects that. In moving to digital courts, where we take bulk liability orders, 100, 200 at a time, to speed things up rather than individual court appearances. So we are making progress on the liability order part of the process. Sanctions, unfortunately, is a personal appearance in court. Again, we keep working closely with the court service to see if we can speed that up. But some of it is legislated, and we can't get away from the fact that you need a liability order to move forward.
So the emphasis obviously is not on accuracy, it's on speed. So put 200 liability orders to the courts all at the same time with no opportunity at all to look at individual cases. Well, I'm now joined by two people, Lee Windsor and Craig Bullman, who've had actual experience of that process. Craig, tell us about your story.
Right, my story begins back in 1996, well, actually 1995, when I first split up with my ex-wife. I went straight to the regimental admin office, set up a private payment, personal, to pay for the children. And then 1996, just before my deployment to Bosnia, started getting letters from the CSA, and they were demanding money. And I was like, well, why you coming after me? I'm paying for my children. Anyway, it got so bad. In the end, I left after 16 years service because I just couldn't cope with their harassment. Come 2009, I got a liability order for £12,000.
Based on what?
Based on nothing. The dates that were in the liability orders were actually dates from when I was on a nil assessment, because I'd been out of work because of a back injury. So when I challenged it, they became really militant and enforced a detachment of earnings order at 40% of my salary, and they knew that I couldn't afford that.
Did they re-examine the assessments they'd made?
No. I complained about it. They just, because I challenged them, it's like, how dare you challenge us? And then slapped on a detachment.
Can you not ask for a mandatory reassessment?
Mandatory consideration. At the time, I didn't know nothing about all of that sort of stuff.
And they didn't tell you that there was a means of questioning it?
I just kept complaining via email, and eventually my case ended up with ICE, and then ICE took the side of the CSA, and then it got to the Ombudsman, and they were going to take the side of the ICE report. But then when I realised that they'd missed my ward cement pension out, the Ombudsman asked the CSA, and then that was it. They admitted that they'd used incorrect enforcement, and the accuracy of the liability orders was totally inaccurate, and the information on there was misleading as well.
So they've admitted they've made a mistake. So was that the end of the story?
No, I was actually, when they admitted all to the issues, I'd already been made homeless. I'd been sent home from work with a severe breakdown, and I lost my employment as well as a result of it, and I've never recovered from it.
And of course, if you tried to question them in a court of law, what would have happened?
Nothing, because of Section 33, subsection 4 of the Child Support Act 91. It precludes the justices from questioning the calculations.
Well, perhaps we should just have a look at that legislation and what it says. And so there it clearly says that once a liability order has been issued, it cannot be challenged in a court of law. That is to say that the judge or the magistrate can't look at the figures. So you could come into court with a whole load of papers that proved quite clearly that you hadn't been earning what they say you were earning, and yet the judge or the magistrate is prohibited by law itself, from looking at that.
Yep.
Now, is that Magna Carta?
Well, it's certainly a breach of Clause 29 of the 1297 enactment. That's where we got Article 6 from, is from the 1297.
I think our viewers may not necessarily understand all of that, but the essence of this is that you can't challenge this in a court. Now, you yourself have said, right, that's against natural justice.
It is.
And therefore, you're going to challenge that itself, that provision itself, you're going to challenge in a court.
Yes.
And tell us how far that's got.
Well, I put an application for a declaration of incompatibility because Article 6 of the Human Rights Act 1998 has consistently been compromised by Section 33, subsection 4 of the Child Support Act 91. You cannot, well, your right to a fair trial has been totally whitewashed.
But of course now there's not even a necessity to go to court.
No.
Because the Secretary of State has decided that he himself can just issue an order.
Well, I would say that's a breach of the separation of powers.
Well, let's see what he has to say. This is Lord Younger.
And so this bill makes important improvements to CMS enforcement processes by amending existing powers. Once commenced, this will allow the Secretary of State to make an administrative liability order where the paying parent has failed to pay an amount of child maintenance without the need to make an application to court.
So even if you win your incompatibility fight, he can make the order anyway. So it seems to be loaded against you.
Well,
so that's your experience, Craig. Lee, tell us about yours.
Yes, so a case was opened up against me in 2008, and I was paying, sending me war pension that they asked if I was receiving any benefits. They totally disregarded it, and where I should have been on the flat rate assessment. In 2012, 13, I started complaining about that and taking that into account. And in 2014, they admitted they made an official error.
So they actually admitted they'd made an error.
An official error, yes.
But that wasn't the end of the story.
No, they administrated my case and said I had overpaid by £6,000 odd. I thought that was going to be it,
yeah.
But they actually overturned that decision, obviously with variations put in by my ex-partner, and went back to the start of the case with the arrears of over £18,000, which was totally made up. I then had to go down the route of a mandatory reconsideration and ended up at a tribunal in which the judge said it was out of his jurisdiction and he couldn't make a decision.
So you go to a tribunal and the judge can't make a decision?
He couldn't make a decision. He told me to have to re-complain to the child maintenance service.
the same happened to me as well.
And when you complain?
Again, I went down the complaint route and their answer was, look, this is it. We're correct. I went to ICE, like Craig, to the PHSO, and they've all sided with the CMS. And then they started now going for liability orders, in which I went to court and the Portsmouth magistrates granted the liability orders. And again, I wasn't allowed to show any evidence because of this Support Act 1991, Section 33, and liability orders were granted. So I've tried to appeal against them, in which I went to the FRC, Financial Remedies Court,
yes,
as told by Judge Hess. Is it Judge Hess?
Yeah.
And that was a way to appeal the decisions with an N161 form. And they've basically replied to me, no, this is not how you do it. Return to the CMS. So there's no clear path of appealing these liability orders, and I just cannot get rid of them.
So in summary, you can have an order made. Mm-hmm. They can then admit, as in both your cases, that there was an error.
Yes.
But instead of that being the end of the story and then them putting everything right because of the error, they persist with the original demand. Mm-hmm. And in summary, there is no clear court route for you to be able to challenge that demand. No. That is what it comes down to.
Yes.
So what they say is law. Mm. Yeah. What the CMS says is law. And that is, of course, completely contrary to natural justice. It is actually contrary to Magna Carta. And it is contrary to the British Convention that government can always be challenged in a court of law. And so it would seem that the CMS enjoys a uniquely privileged position in government in this country. Now, I'd like to bring into this conversation Kevin, who's currently serving with the RAF. And Kevin has a slightly different slant on this one, but with the same result. Kevin, hello.
Hello there.
Thank you for joining us. Can you just give us a run through of your story?
My ex-partner withheld my children whilst I had a 50-50 equal shared care order given out by the family courts. The Child Maintenance Service contacted myself and on their initial gambit said that, and I quote, "You will have nothing to pay through the Child Maintenance Service if you are sharing equal shared care." I provided my court documents and put my faith in them, but told them that she was withholding the children, at which point they completely drew a line under the court order and said, no, So therefore, there is a case to answer, which ultimately resulted in me being deducted from my earnings.
So a court decides that it's 50-50. Your ex-partner decides that it's not 50-50 after all. And the CMS then, without any amendment to that original court order, decides to levy from you child maintenance. Is that right?
That's correct, yes.
So once again, the CMS is acting as a law unto itself.
Very much so.
Yeah.
And then you are hit financially by going back to the courts to enforce the order. So you're essentially paying twice each month, one to the receiving parent and one to your legal team to enforce the court order that you already have.
And of course, it is very common, as well I know, for women to use the children at the bargaining point with an ex-partner.
I'd say it extends all over the spectrum, so males and females. It's just the service affording everybody to completely turn a blind eye to any court order, break it, and there is no financial result. And for them, there's just a benefit, as the CMS will turn around and state they do have a case for receiving funds.
Kevin, thank you very much for sharing your story with us. So, what have we got? We've got a government department that apparently just can act out with the law, independently of the law. The law is obliged by law to rubber stamp what they decide. How can that be just?
So in this Reform UK special programme into the impact of the child maintenance service on people's lives, it's brilliant to be able to look into individual case studies, and in particular the impact on those brave men and women in our armed forces. I'm delighted to be joined in the studio by Mark and Tony, and then also a guest down the line. Guys, thanks for being with us. Look, I know this is difficult, but it's such an important topic. And what I'm actually going to do first is play a clip from Caroline Noakes, which was on the 27th of February, so very recently, in the Houses of Parliament, just about the impact, the distress that's caused on people working in the armed forces. Let's just take a look at this.
When constituents come to our surgeries to discuss their child maintenance service concerns, cases, complaints, they are almost invariably very distressing meetings that we have with them, including a man in tears because he simply couldn't get the child maintenance service to adequately explain the arrears on his account. On the phone, they would tell him that he owed nothing, and then days later he would get a letter telling him he was several £1,000s in arrears. They would then attach a deductions of earnings orders to his employer, the Ministry of Defence, whereas he said it became professionally very difficult for him because he wasn't allowed to be in debt. Yet whenever he spoke on the phone, he was told that he was not in debt. So look, there are complexities and confusions within the system that still prevail.
Well, that's Caroline Noakes talking about it. Mark, just tell us a little bit about your story and the impact on your life.
My story, right, well, started around 2009. And an assessment was made which predated my daughter's birth.
That's an assessment of the income?
Assessment of my income,
Before your daughter's birth?
Yes, so the case started whilst also my daughter was here, but the date they used predates her birth. Right, so they did an assessment, and then at that time I was on about probably 30-odd K a year. The assessment came through and it's assessed me on 70-odd thousand pounds.
70,000?
Yeah.
But you were earning about 30,000?
About half of that. So I then I queried it. I said, well, I've never earned that much money. They said, well, that's the assessment. And because I hadn't responded within a certain time frame, they said I had to pay that much there and then. I gave my present employer's details, which was about 25k a year, but they still persisted with the 70-odd thousand pounds. And they made their calculations based on that and then chased me ever since. So I've been querying and sort of going back to them, saying, look, this is wrong, and could you correct it?
And where did it end up? Did it go as far as a liability order?
Yes, so later on down the line, the liability order was heard, but that was heard in a place called Salford, some 200 plus miles from where I live. So the liability order was granted, and then at the later stage, a charging order was then placed on my house.
So they placed a charging order, and did they try and sell your house?
Yes, this has been going on for some time now. So up until 2019, they tried to get a possession order of my house to recover what they alleged was about nearly £9,000.
Unbelievable. And then you actually showed you had some proof of payment. What did they do then?
Yes, I had some proof of payments. They still went ahead with the charging order. I went to court, and one of your earlier colleagues turned up with me. He helped me out. The courts didn't grant the possession order, and so there I promised to make a payment of £150 a month until this was sorted out. Since then till now, I've been trying to sort out the arrears and trying to sort out the liability order with the CMS.
I mean, just extraordinary. And it seems to take, I mean, this has been like over a decade.
Yes, yeah, definitely so much so.
I just can't believe the level of, the time frame and the level of errors just seem absolutely huge. And just finally, Mark, I mean, how's this impacted on you, on your own state of mind?
Okay, so I'm an ex-serviceman. I'm very, very, very proud of it.
Quite right too.
And since leaving the services, I've played rugby, boxing. I've become a rugby coach for a youth team, paragliding, adventure training. So those are the things that are my hobbies.
Sound brilliant.
Yeah, so I try to keep active. I try to, carry on the military sort of ethos type thing. I've then, since the CMS have come into my life, it's just chipped away, chipped away, chipped away. I don't recognize myself now. I'm not as adventurous as I used to be.
It's stripped away your whole sort of sense of trust in the administration.
Yeah.
I mean, you served our country. The very least you would expect is that the administration would properly serve you. And it's debilitated you, it sounds like.
It has. I mean, during my time in the service, I haven't experienced any PTSD. I think I came out pretty unscathed. Since then, since the CSA have gotten involved with me, I'm getting palpitations. I'm having to speak to sort of counsellors just to sort of get over the emotional impact of this. There's been times when I've
been really tough. I can sense, Mark, that it's really, really tough. Well, sharing these stories is helping thousands of people. That's why it's so crucial. Let's bring in Tony. You also have had a difficult experience. Just, again, share with us, Tony. You're a boxer, a serious boxer, I gather, in the forces.
My case started back in 1993. There was the payments they asked for were wrong. They didn't take into consideration my wife and my new wife and my children. We put up with it. I was paying regular payments for years. I got promoted to sergeant. I was #1 in the army at boxing. I was a confident, strong man. And then within 12 months, I'd be in the colonel's office. I'd be in tears. I was like, this is not me. They upped my payments by 75%. My wages did not go up by 75%, but their payments I had to pay. And that caused a massive amount of stress on me, on my family, my wife,
And you obviously told them that they'd got the amounts wrong.
Yeah, I argued the case. They didn't care, and that was just the beginning of a war with them. I had a breakdown. I broke up with my wife, drinking heavily. I did something stupid one day, which I regret.
And you don't need to go into that, Tony. The thing is that you were doing the right thing. You were serving your country.
Paid religiously, never missed a payment, did everything right, and then he upped it. And that was just the beginning, because when I left the army, it got even worse. Thanks to Craig, who was on earlier, I don't know how I'd have managed. It was in the papers about 2 years ago where I was paying, my ex-wife passed away, and I was having to pay her husband the arrears, which were fictitious arrears, which I've proven, to a man that didn't even raise my children. And he didn't pass the money on to my children either, as my daughter told me.
And your children by then were adults?
Yeah. My son was 29, my daughter's 31.
Tony, thank you for sharing this, because it's so important that others understand that they're not alone with their own issues, particularly in the armed forces, just left the armed forces, and people have got to talk about this thing and share it with people. Let's just look at this clip with Arlene Sugden, who's the director of the Child Maintenance Service, just about the process, the accountability and the impact. Take a look at this.
Being new into the department, I'm already aware, having seen some of the correspondence that I've had to sort of look at and sign off on some absolutely tragic cases. I think it's absolutely appalling that this can, or cases can lead to people taking their own lives. I mean,
could I just pick up the point you were making, Arlene, that when you become aware that a client of the service has taken their life, you carry out an investigation. What comes out of that? I mean, there's an investigation report, I suppose. What do you do with that? Does anything get published? Just talk us through the...
Nothing's published. I mean, the internal review process is more transparent, but we very much just look at the case notes. A lot of the time, we've had no contact with that parent for quite considerable time. So what we're looking for is any involvement of ourselves that could have had an impact. And if we think that's the case, then that's when we would refer it to the department's internal review process. But it's very much us looking at our own interaction with that parent's contact history and determining if we could have done something that may have been the final straw sort of thing.
David Lynn wants to come in, and then Sean Bailey.
Can I just ask a supplementary to that? I mean, doesn't that therefore mean the department, in essence, is marking its own homework? And is that appropriate?
There you are, that's the key point. The department's marking its own homework when a situation is so serious that tragically it ends in suicide. Well, I'm now joined down the line by Tony, who's a decorated Marine, to discuss his own case. Tony, thanks for being with us. You've been listening in to Mark and Tony here in the studio. Just tell us briefly about your own experience with the CMS, please, Tony.
Yeah, thank you, chaps. Again, served 7 years as a former commando, gained my wings, worked with the Navy SEALs and US Marine Corps, and recommended for selection at the age of 18. My involvement with CMS, or CSA at the time, Child Support Agency, stems back to 2011. I was on operational tour at that point, from March to October 2011. And when I returned home, I received a multitude of letters where deduction of payments were being taken. And this was a calculation based on other bonuses which other veterans have experienced, such as danger pay, living allowance, and so forth. So this put me, financially behind on my own personal bills, and I wasn't able to perform as a soldier.
Unbelievable. And you ended up... Did they offer you a paternity test in your situation? What's the situation there?
So I queried parental rights straight away. I stated I'd like a DNA test. They refused on a number of occasions. Thankfully, I had my unit come forward, and they said they would look to cover the cost, the £200 cost for the DNA tests. When we were trying to get the details for the parent, CSA, Child Support Agency, declined due to data protection, and we weren't able to get any further.
Wow! Even though you had a legal right to do that, what's been the overall impact on you, Tony, with this really difficult experience with the then CSA? How's it impacted on your mental health, your state of mind?
Just like Mark and Tony, and a number of other veterans, I feel like I'm a shell of a man. My career went downhill. I got injured in Afghanistan and, struck with an IED. I'm very fortunate on a foot patrol, where I had lacerations to my arms, face, and now a confirmed diagnosis of PTSD. And, showing emotion is, I think it's a sense of weakness. And, we put our pride on the shelf.
It's so important, though, Tony, to share it, because it's not a sign of weakness. Actually, it's a sign of strength to talk about it so that people can understand, because it's helping you and it's helping others. And I think that's absolutely vital. Well, I'm really hoping that with these discussions that we can get through this, that it's helping all of you, Tony down the line, and indeed Mark and Tony in the studio. Thank you so much for sharing that with us, Tony. It's really important. Keep talking about it, and we wish you well. Thank you very much indeed, guys. Well, there we are. 3 more shocking experiences where errors, a lack of care within the Child Support Agency and the Child Maintenance Service is having an absolutely devastating impact on the lives of those who've served our country. It's not acceptable, it's got to change, and that's why we're talking about it. And coming up, we're going to be reviewing all of these cases and what we need to do about it with Anne Widdecombe and Noel Willcox. Stand by. So on this Reform UK special into the impact of the Child Maintenance Service on the lives of those who've served our country, we've heard some incredible experiences. And the truth is, I mean, the guys, they could have talked for double the length of time. They didn't actually refer to their suicidal thoughts, cancer impacting on some of their lives, the stress, the tension. You heard also about just how much they became shells of their former selves. Absolutely devastating. And we can look at this graphic on the screen, the timeline. This has been going on not for a couple of years, this has been going on for 30 years. Just on this screen here, originally it was the Child Support Agency under the Conservative Party, then the Labour Party, then it became the Child Maintenance Service under the Conservative Party. With these clips, it seems that Westminster's aware of it, but frankly, not doing anything about it. And this level of incompetence is unbelievable. We've got Anne and Noel back in the studio. Reflections on these experiences. Anne, you first.
Well, it isn't just incompetence. There are remedies to incompetence. It is something much worse than that. It's intransigence. It's about a department being a law unto itself, quite unlike any other government department I've ever known. And it is also a question of not caring. I mean, they do not care. I mean, one person told me that he was sobbing on the phone to them, and the girl actually laughed.
Utterly mind-boggling that could be the state of mind. You've touched about intransigence, incompetence. Noel, is it actually in some cases worse than that? Is it deliberate? I mean, because sometimes you can't believe this. If you don't understand something, sometimes I've got an old expression, follow the money. I mean, there's a lot of money involved here now.
You actually taught me that, Richard, follow the money. So
you listened to me?
I did actually listen to you. Yeah, if you do follow the money, there's something actually quite alarming here. So in the recent National Audit Office report, I found a receipt, that was where money was collected but not passed on to the receiving parent. And in that report, it contained quite disturbing information that the CMS had actually carried out an investigation. And they found other instances of where this had happened. Do you want to actually know how many cases that this was?
I mean, absolutely, we need to know.
Okay, so there was 12,173 cases where the sum of about £2.2 million was collected when those cases were closed.
I mean, how does that happen, Noel?
Look, I genuinely don't know how that could possibly happen. But also, this is where the cases were closed. But also in another instance, Richard, there was 12,293 cases where it was switched onto direct pay. So why has that money still been collected when that paying parent is paying the receiving parent direct? There's no reason for the child maintenance service.
So is that a double payment?
It's essentially, yes, it is a double payment. Now, if we look at the figures, approximately £4.4 million has been collected but not passed on to the receiving parent. And this is quite often something that we hear of consistently, that the receiving parents are saying, we're not getting this money, but they're blaming the dad, and then coming up with this narrative that these are all deadbeat dads.
So do we think that that money is sitting in some account through incompetence at the CMS, or do we think somehow it's going into the wrong account, someone else's account, or a bit of each?
Well, all I can say, Richard, is that I've checked all the account balances on the NEO report, and I can't find where this £4.4 million has been listed anywhere on the books in any form of audit trail.
So the answer is we don't know, but it's, in a sense, it's a serious question, and these things have got to be picked up by members of Parliament and asked of the CMS.
Well, there is a track history of caseworkers from the Child Maintenance Service who have actually been sent to prison. And I've got 3 that I'm aware of right now, and these are quite significant sums of money.
I mean, it beggars belief. Have you ever, and you touched earlier that it was like the worst department you had seen.
By far, by far.
By far. I mean, that's a really serious statement and observation, because you've seen a number of these departments.
Oh, I've seen a lot of them, and I was in 3 different departments over the course of 7 years when I was in government. And I have never known a department that was so able, and is enabled to do by law, to just be its own judge, its own jury, and its own executioner.
I mean, that just sums it up, and it feels like that it's intransigent, it's incompetence. There may be a level of fraud in there.
And it's uncaring.
And it's uncaring.
Totally uncaring.
Totally uncaring. And we've heard about the impact of that lack of care on people's lives. So, to wrap up, what do we need to do about it? I mean, we're addressing it at Reform UK. No, what would you like to see happen? Let's just say, right, we're going to do this, this, and this.
Well, firstly, Richard, can I just say it's absolutely fantastic that Reform UK are taking a really active interest in this, and I think it's something that, credit to you, for actually taking this on.
It's a big effort.
Yeah, it is a huge effort. It's a lot of research that we've all been doing. A lot of meetings regarding this, and it's such an emotive subject. And we've seen the social devastation that this is causing across the whole family dynamic. So what I would like to see is a much, much fairer system. That's what I would like to see.
And so we want to talk about 50-50 shared care as a starter?
Yeah, as a starting point, I would definitely say 50-50 shared care, of course, where applicable.
Yes.
Yeah, 100%.
Absolutely.
I would like to see an automatic review now being carried out by anybody who thinks that their assessments are wrong. Not just that they don't like the assessments, but that they're wrong. I would now like to see a full-scale automatic review of every single case. And yes, that will be expensive, but it's a justified expense.
And within a rapid time frame.
Oh, within a very rapid time frame.
Yeah, absolutely. Because that's the other thing that struck me with all these cases, is it goes on and on, not just months, but years and years and years, sometimes a decade. Mind-boggling how this can happen.
And it can go on after the children have become of age. It can still go on.
But Richard, also as well, one factor that we're not considering here is the cost to the taxpayer to run this department as well. We're looking at about £300 to £400 million a year to run this department.
And so we should actually have mediation is a key factor, as opposed to the current system just seems to be determination and there's nothing you can do about it.
Determination and enforce is currently what we're seeing at the moment.
What we should have is mediation.
It's got to be mediation, and it's got to be means tested on both sides. Yeah, so that it's fair and it's equal to both parties involved.
Absolutely essential. And of course, we focused on armed forces personnel, either serving or recently departed. But actually, there are tens of thousands, if not hundreds of thousands, ordinary civilians basically suffering similar experiences.
Absolutely.
And it's really serious. And look, we've heard from the DWP before when we got statements from them, but it just struck me as being their usual sort of wishy-washy, it's all okay, there's nothing to see here, Gov.
They don't seem to understand actually what goes on in their own department. They don't seem to understand it, so they say things like, you can go to a tribunal. What actually happens is that while you're arguing with the CMS and imagining that they're taking account of what you're saying, they've already gone and issued the liability order, and then there's no tribunal.
Well, we could go on for hours and days almost on this subject. It's so big, but look, a massive thank you to you. And for those of you who've been watching and listening, if you want to get in touch, there's a couple of addresses to get in touch with. First is cmswatch.org. That's an organisation dedicated to this issue. And if you get in touch with them, or alternatively, if you contact us at Reform UK, the email address hopefully will come up on the screen, info@reformparty.uk. This is a vital issue. Another area where, frankly, the government and administration department is utterly failing. We've heard it before. I fear we're going to hear it again. But we at Reform UK, we're utterly determined. Great nation, badly run, badly led. We can do so much better. Thanks for watching. Look forward to your feedback.